9. Adoption. Adoption is the legal process which establishes the relationship of parent and child between persons not so related by birth. According to the usual understanding of the lay person, it is the act of taking the child of another into one's family and treating him as one's own. Adoption, an ancient practice. The practice of adoption was sanctioned by early civilizations as a method of caring for children. For some reason, it was never accepted as a part of the common law of England, and so could not become the practice in this country without statutory provision, except in states which based their legal systems upon the Roman law. The social and legal aspects have not developed side by side, but it is difficult to adhere strictly to one or the other in any consideration of this alliance, which can spell so much happiness or disaster. Though it is possible in most states to adopt an adult, this is not a usual practice, and we think of the term as applicable only to children and usually to very young children. Early legislation. The first adoption law in this country was passed in Massachusetts in 1851 and, like early statutes in other states, put emphasis on the rights of inheritance and the legal privileges involved, instead of upon the social aspects of the relationship. Adoption by deed. The simplest form of adoption proceeding is by deed, which is certified and filed as a transfer of property is filed. This process completes the transfer of the child from one set of parents to another. Statutory provision still allows this procedure in Louisiana for children over 18 and for adults. While it may have established inheritance rights for a child, it is a question whether or not it ever took away all parental rights without the written consent of the parent or parents. Certain rulings on appeal have held that, without the consent of the parents, adoption by deed would hold for the inheritance of property but would not stand as an adoption otherwise. Statutory provisions have now practically done away with this form of procedure. Jurisdiction. The general practice is to require a formal proceeding before a judicial tribunal, which is usually the probate or orphans court, probably because the first conception of adoption was allied with inheritance and support. It was placed under the jurisdiction of the court having to do with property rights, where more socialized aspects of adoption have permeated the law. The family courts or even the juvenile courts have attained jurisdiction. The great danger in placing the jurisdiction in the probate court is that as this court has jurisdiction of property, which is one of the most complicated and technical divisions of the law, the adoption procedure is likely to be rigid with little consciousness of the social factors involved. There may be no machinery for the social investigation, which should be an important part of every adoption proceeding. On the other hand, there is ground for the belief that the jurisdiction in adoption cases should be kept in the court which historically had to do with matters of probate instead of placing it in the court that has to do with the delinquencies of parents or children. The court having jurisdiction of adoption may be a county probate court, some other county or circuit court, a juvenile court, or a court covering a larger or smaller unit than a county court. The practice which governs the jurisdiction of the person is quite varied. Some states require that the petition shall be brought where the petitioner resides. A few provide that jurisdiction shall follow the residence of the child, and all the other states provide that the petition may be brought either where the petitioner or the child resides. This gives a non-resident the privilege of adopting a child in the state where the child lies. Some of these states, by implication, allow a non-resident to adopt a child because there is no residential or jurisdictional restriction which excludes a non-resident from petitioning. Adopting parents sometimes prefer to have the legal procedure in records where the child lies, for if the petitioners live in another state, they think their friends are less likely to have access to records which will give information adverse to the interests of the child. From a legal standpoint, however, the best procedure seems to be that the residence of the adoptive parents should be the place of jurisdiction. Some states provide that if a child has been abandoned or for some other reason has become a ward of an institution, the court where the institution is located shall have the right to grant adoption. The consent of the institution is required also. Change of birth certificate. To eliminate any difficulty about records, 5 states make provision in the adoption law for the court to send a report of the adoption to the state registrar of vital statistics, and he is authorized to change the birth certificate so that the adoptive parents appear as the natural parents. Other states make similar provision in the vital statistics law, and 6 states provide for registration, but do not require a change on the birth certificate. Parties to the adoption. There are at least 3 parties or sets of parties concerned in the adoption proceeding which is started, as we have seen, by means of a petition to the proper court. Alabama, Delaware, Louisiana, Maine, and North Carolina. They are the party or parties wishing to adopt the child, the natural parent or parents or guardian, and the child. While there are restrictions concerning the petitioners, these largely refer to age, reputation, and certain legal formalities and not to the motives underlying the act. For instance, the state law of Massachusetts specifies that a person of full age may adopt a person younger than himself, and some states specify that the person who is adopting must be at least 10 years older than the one who is to be adopted. Louisiana, Montana, Nevada, and Texas do not allow the adoption of a person who has the blood of another race, such as the Negro or Mongolian, by a white person. Most statutes provide that if the person who wishes to adopt another is married, the husband or wife must join in the petition, or at least consent to the arrangement. As they will both become the parents of the child, this seems the only logical policy. In addition to this, many statutes specify that the petition shall include the names and addresses of the petitioners, the name and age of the child, and the name by which he is to be known. Also, the names and address of the natural parents and any information which is known about them, except that if the child is illegitimate, a few states, including Illinois, Massachusetts, and New York, do not allow any reference to illegitimacy in the petition or the decree. As adoption severs the child's relationship to its own parents, it is only right that the parents should have every opportunity to appear in the interests of the child and consent to the change of status. Therefore, unless a parent is mentally incompetent or morally unfit, or as California, Montana, Nevada, New Jersey, New Mexico, North Dakota, Oklahoma, South Dakota, and Utah. Idaho requires that the person adopting must be 15 years older than the person adopted, lost custody through divorce, or the child has been placed under the control of some child-caring agency by the court. Consent of the parents is required by statute in all states. If the child is illegitimate, the consent of the mother only is required. If the parents are dead or are incompetent, and the child has no guardian, a State Department or other agency serving as guardian ad litem or next friend can represent the interests of the child and give consent to the adoption. All but 8 states also require the consent of a child to his adoption if he is over a specific age, which is usually 14, though in California, Idaho, Montana, and New Mexico it is 12, and in North Dakota and in Michigan, under certain circumstances, it is 10. In many states, the law specifies that the petitioner must appear in person. Also, the parents or guardian must appear unless they live outside the state, or for some other good reason are unable to be present. This requirement may be waived in that case, but even then the consent must be shown in writing. In most instances, it is shown by the petition which is signed by the natural parent or parents. Sometimes adopting parents do not like to have the natural parent or parents know who is adopting the child, especially if the child is illegitimate, and the signature of the mother without this knowledge is legal in some states. Social investigation. If there is any branch of legal procedure dealing with the lives of human beings which needs the aid of a social investigation, it is adoption. The court should concern itself mainly with the welfare of the child and demand a searching inquiry into the fitness of the adopting parents. The growing interest in the welfare of the adopted child has been reflected in recent legislation, and about half of the states now authorize a social investigation either by a state agency, such as the Department of Welfare, or some other state department, or by some person or agency appointed by the court having jurisdiction. The trend is increasingly toward greater protection of children and a more careful examination of the home to which the child is going. State statutes specify that a judge shall be satisfied that the petitioner is of good moral character, of reputable standing in the community, and of ability to properly maintain and educate the child whom he wishes to adopt, and also that it is for the best interest of the child to be adopted. This is probably as far as the language of the law can be expected to go. And yet there are more subtle aspects of this age-old social institution which are outside the realm of legal phraseology but which affect the social side of adoption acutely. An eminent child psychiatrist has said, who is to appear in the interest of the child and inquire for him, "Why do these people want me? What kind of people are they? Are they thinking of having someone to support them in their old age? Or do they want something to play with for the moment? What have they done to demonstrate that they are capable of bringing up a child? Has it ever occurred to them that I might not have chosen them had I had any say in the matter? How old are these prospective parents of mine? Let them consider how old they will be when I am in need of counsel and advice in early adolescence. Only when the emotional urges and motives of the petitioner, as well as the emotional needs of the child, are considered, can there be a thorough and sympathetic understanding of the whole situation. To how great depths the social investigation penetrates depends upon the facilities at hand for the study of the individual, and also upon the personality of the one who makes the investigation. Every children's agency is familiar with the results of ill-advised adoptions like the following. A couple with one child have lost 3 children at birth. After the loss of the 3rd child, they were advised by their family physician to adopt a child who was born of an unmarried mother at the same time and in the same hospital as their own child. Without knowing anything about the antecedents of this child, they took him, intending to adopt him. Actually, they never went through with the legal procedure, though he went by their name. This was a bad situation from the beginning, for they were then in no emotional state to undertake the care of this child. The later illness and death of the foster father made family life impossible, and 3 years spent in rather rigid schools did not help to solve the problems of this boy. At the age of 11, he was accepted by a child caring agency in the state where he was born, a very unhappy little boy, having many deep-seated behavior problems and badly needing psychiatric help. If any investigation had been made by a children's agency, this situation could have been avoided, as the parent's emotional instability would have been discovered. Trial period. Even when every precaution has been taken before placement, social agencies recognize that a trial period is essential in order to be quite sure that the relation is going to be a satisfactory one. Many states have seen the wisdom of this and have provided by statute for a trial period before the decree is granted, though in some states this may be waived at the discretion of the judge. The trial period varies in the different states from 6 months to 1 year. During this time, supervision is essential, for otherwise the trial period would be of no value. A little girl was taken from a county institution and was adopted without any investigation or any waiting period to prove the stability of the arrangement. Before the child was 5, she was the victim of the most distressing sex abuse. Supervision of this home would have shown the dangers even if the necessary investigation had not been made before the placement. The importance of a waiting period is closely allied with jurisdiction, for surely when a period of waiting is a part of the required procedure of every state, supervision will be easier if the parties are within the jurisdiction of the court. This supervision is often given now by children's agencies upon a reciprocal basis, and a report is sent to the agency which will be responsible for the adoption. For example, a child born in New Hampshire was taken into the family of her aunt in Connecticut after an investigation of that home by a Connecticut agency, with the understanding that the child should be adopted at the end of a year if conditions were still satisfactory. The Connecticut agency supervised during the period, but the adoption was consummated in New Hampshire. Record of adoption, usually a judicial decree of adoption, like any other decision, is a matter of public record, but a few states recognize the unusual nature of the proceeding and provide by statute that the record shall be open only to the parties in interest, their attorneys, or to an authorized state department, unless there is an order from the court. Complete change of legal status. When an adoption decree has been made by the court, there are certain rights and obligations which affect all the parties to the relationship. The legal status of the child is completely changed. The natural parents are deprived by law of all legal rights to the child. These are transferred to the adopting parents, whose rights and duties are the same as if the child had been born to them. The first result of this relationship to the child is the right to bear the name of the adopting parents. It is as much his legal name as if it has been conferred by birth, and he is entitled to support, care, and education the same as an own child. The adopting parents, on the other hand, have the right of custody and the right to the child's services and earnings during minority. Both parents and children usually have reciprocal rights of inheritance, though this is not always true. As we have seen, in early times the desire to have an heir was one motive underlying adoption. Though in most states an adopted child inherits equally with an own child from the parent's estate, it has generally been held that the adopted child cannot inherit through the parents from their ancestors or kindred. So if there is an own child in the family of the adoptive parents, both children inherit equally from the parents, unless there is a will which provides otherwise, or a statute which specifies that only heirs of the body may inherit. but the adopted child will not inherit from grandparents who die after the adoption took place. In a Massachusetts case, it was held that an adopted child had the right of inheritance as against an uncle and aunt in the property of a sister by adoption. This decision was on the ground that the adopted child would take the same share in the parents' estate as if he had been born to them, and would stand in the same relation to legal descendants of the parents, but to no other kindred. The decisions in Washington, Iowa, and New Jersey have been according to the same interpretation of the statutes. 12 states provide that an adopted child does not lose the right to inherit also from his natural parents. Annulment of adoption. The relationship of adoption is unlike guardianship in that it is a permanent one. But mistakes may be made and conditions may change, and so several states have enacted laws to protect both the child and the adoptive parents from conditions arising after adoption. Some states provide for annulment if the adoptive parents violate their agreement for proper care and treatment of the child. In Minnesota, if within 5 years the child has developed certain defects such as feeble-mindedness, insanity, epilepsy, or venereal disease from conditions existing prior to the adoption and then unknown to the adoptive parents, the decree may be annulled. The law in Alabama, Arkansas, California, Iowa, Missouri, Ohio, Utah, and Wisconsin is similar to this. In a few states, the natural parents and the child are protected against untrue statements made by the adoptive parents at the time of the adoption, and the court can revoke the adoption if any of the material allegations were untrue. Often the most practical way to sever the relationship in an undesirable adoption is to proceed as with a child who is living with its natural parents, and either prove through juvenile court proceedings that the child is neglected or petition for guardianship of the child. Adoption by acknowledgement. Throughout this chapter, we have considered legal adoption only in the statutory procedure which has been established in the various states. In connection with this, it should be mentioned that in 8 states, namely California, Idaho, Montana, Nevada, North Dakota, Oklahoma, South Dakota, and Utah, the father of an illegitimate child can adopt it by making a public acknowledgement that he is the father, and receiving it into his family with the consent of his wife, if he is married, and otherwise treating it as if it were legitimate. This is in contrast to the rule that the child, who has been accepted by foster parents without judicial procedure, is not actually an adopted child in the eyes of the law, though the foster parents look upon him as their child. Because there has been a good deal of this sort of placement by parents and well-intentioned persons, some states have placed restrictions on the transfer of children by their parents without an order of the court or the State Department of Welfare. Restrictive laws relative to adoption. Laws have become more restrictive as they relate to the policy of maternity hospitals and child-caring institutions, from which many children are taken for adoption. However, some very unsavory practices still exist. A well-known judge of a juvenile and domestic relations court is authority for the statement that prior to 1922 it was the common practice in Virginia for commercial maternity homes virtually to sell babies born in their institutions. A fee was charged to the expectant mother when she was admitted to the home. A few weeks after the birth of the baby, she was permitted to leave the home and her baby upon signing her consent to an adoption paper which did not name the adopting parent. Married couples or individuals who desired to adopt a baby would come to the maternity home, look over the babies as though they were so many puppies, select the one whose appearance appealed to them, pay a fee or donation of $50, $100, or more, and with the aid of the matron or superintendent of the home, secure from a local court immediate approval of the adoption, without any inquiry as to the moral fitness or financial responsibility of the adopters, and with no examination of the baby to determine its physical or mental condition. The responsibility of the state. Undesirable conditions existed in other states and still exist to some extent today. However, the feeling that adoption is a responsibility of the state is becoming increasingly strong, and legislation relating to it shows a gradual change from a transaction that was primarily contractual to a procedure which places emphasis on social well-being of the child. There is still much to be done, nevertheless, before every child will have adequate protection, which is possible only when there is a complete social investigation, a trial period under supervision before the decree becomes final, a provision for annulment if the welfare of the child demands it, and Finally, a provision that some department of the state, preferably the State Department of Welfare, or a division of guardianship shall pass upon all adoptions and supervise social agencies or persons who are active in bringing about this important relationship.